Hello everyone, welcome to this evening's webinar, Understanding Statutory Pay in the Independent Sector. My name is Steve Pulsford. I'm the Head of Operations for the Royal College of Nursing in the South West region, hosting the event this evening. Just a couple of things to say before we start. This webinar is being recorded and it will be made available on the RCN website. Got a presentation to run through with you today, and there's an opportunity at the end of the presentation for questions and answers. You'll see a Q&A section on Teams, so please do type in any questions that you have in the chat or in the Q&A section, and we can make sure that they're covered by Barry at the end. I mentioned the webinar has been recorded. On the basis that it is being recorded, please don't add into the Q&A sections the sorts of things that you might make if we were a smaller group face-to-face, such as requests to repeat or go back and look at the slides. The website will be available on the internet, my RCN website, to watch and repeat later at your convenience if you want. Again, on questions, can I ask that you ask any questions in general terms about topics covered by Barry, but not specific questions about issues or things arising in your workplace or with individuals. RCN will be able to provide advice and support in relation to any individual circumstances, of course, but we'll do that outside of a webinar. That should be on an individual basis, and so there'll be details in the chat of how to contact RCN Direct if you don't know how to do so. I'm going to hand over now to my colleague Barry Hutchinson, who's going to take you through the slides and the information this evening. Over to you, Barry.
Thanks very much, Steve. Welcome, everyone. Just by way of background, I'm a national officer in our independent health and social care team as part of the Employment Relations Department. My portfolio specifically covers civil service employers, but I do some webinars like this quite often. This webinar is a follow-up to the webinar we ran last week on statutory leave. Some of you may have attended last week's. It was presented by my colleague Jenny Watts. So this is linked to the webinar on statutory leave to explain the types of statutory pay. What we're going to cover this evening is the difference between statutory pay and contractual pay. We're going to look at the different types of statutory pay and how much you will get paid, and I'm going to explain how you will qualify for the statutory pay. Now, a lot of the information we'll be going through this evening is quite technical, but as Rob said, we will be putting a copy of the webinar onto the RCN intranet. So it will be there for you to watch over and over again if you've missed something or you're not quite sure about something. Next slide, please, Rob. So, statutory pay and contractual pay. Statutory pay is the pay that the law says you're entitled to when you're taking certain types of statutory leave. And as I just mentioned, we went through the types of statutory leave at the webinar last week. Now, contractual pay is the pay that you agree with your employer, and it forms part of your contractual terms of employment. The key thing is that your employer must pay you statutory pay if you qualify for it. And your contractual pay cannot be less than the statutory pay. It can be more, but it can be never be less. As an example, holiday pay. Your holiday pay can never be less than the law says you're entitled to, but your employer can pay you more than the law says you're entitled to when you're on holiday. So the basis is statutory pay is the basic that you're at, the basis and the least amount that your employer has to pay you, but your contractual pay can be more than that. Next slide, please, Rob. So the statutory pay that we're going to be talking about this evening, we're going to be looking at all of those highlight on the slide there: maternity pay, adoption pay, paternity pay, shared parental pay, parental bereavement pay, holiday pay, and sick pay. For those of you who were at last week's webinar and have a good memory, you'll find that there are less types of pay listed there than were in the types of leave that were covered last week. That's because some of the statutory leaves that you're entitled to are unpaid. So, for example, individual parental leave is unpaid. So we will not be addressing the unpaid leaves tonight. Next slide, Rob. Statutory pay, this may seem obvious, but it is worth setting out just at the beginning that to receive any of the statutory pay, you must first qualify for it and you must take the leave. You can't receive the statutory pay unless you are taking the equivalent statutory leave. And the other thing to remember is that if your statutory pay hits the threshold, then you will be subject to income tax and national insurance, because all types of statutory pay are subject to income tax and national insurance, and they can also be subject to employee pension contributions if you're in a pension scheme. Next slide, please. So the first one we're going to look at is statutory maternity pay. Statutory maternity leave is up to a maximum of 52 weeks. Statutory maternity pay is only paid for 39 weeks, and it's paid for the first 39 weeks of maternity leave. This is probably a good example to use about the difference between statutory and contractual. Your employer could pay you, if they wanted to and you agreed to it, the full 52 weeks of maternity leave. But what they cannot do is pay you less than 39 weeks of maternity leave. Now, the statutory amount of maternity pay, for the first 6 weeks, it would be 90% of your average weekly earnings. For the remaining 33 weeks, it would be £184.03, or 90% of your average weekly earnings per week, whichever is the lower of the two. So your employer could never pay you less than £184.03, or 90% of your average weekly earnings, because they have to pay the lower of the two, so it can't be less than either of those, but it could be more. And so employers do have enhanced contractual maternity pay, where they will pay somebody's contractual salary for a number of weeks of maternity leave. The law doesn't require the employer to do that. The law only requires them to pay the statutory pay for that period of 39 weeks. Next slide, please, Rob. So to qualify for statutory maternity pay, there are quite strict qualifying provisions. You've got to be employed by your employer for at least 26 weeks by the last day of the 15th week before the expected week of childbirth. Now, it's quite a complicated calculation. So if in doubt and you're an RCN member, contact RCND. They can refer you for support in calculating whether you're entitled to SMP or not. You've also got to give your employers 28 days notice of when you want your statutory maternity pay to start. You also need to give your employer proof that you are pregnant if they ask for it, and you've got to earn at least an average of £123 per week to qualify for the maternity pay. If you don't qualify for statutory maternity pay, then you might qualify for maternity allowance. And again, if you're in doubt, you need to take advice for that. And the final point there, that you would still qualify for statutory maternity pay if the baby is stillborn, but it's after the start of the 24th week of pregnancy, or if the baby dies after birth. Next slide, please. Statutory adoption pay. Similar to statutory maternity pay, the statutory adoption pay is paid for the first 39 weeks of adoption leave, whereas adoption leave itself is 52 weeks, but statutory adoption pay is only for the first 39 weeks. Again, for the first 6 weeks of your adoption leave, the pay amount is 90% of your average weekly earnings per week. For the next 33 weeks, it's £184 and 3 pence, or 90% of your average weekly earnings per week, whichever is lower. Next slide, please. Again, similar qualifying criteria for maternity pay as there is for adoption pay, but the point at which you calculate is slightly different. So you've got to be employed by your employer continuously for at least 26 weeks by the last day of the week in which you are matched with the child, or if it's an adoption from overseas, then it's the last day of the week in which the child arrives in the United Kingdom. Again, you've got to give your employer the notice of when you want your adoption pay to start. And again, you need to give your employer proof of adoption if your employer asks for that proof. And there, again, you have to earn at least an average of £123 per week. Key thing to remember and to be aware of is that you will not qualify for statutory adoption pay if you are adopting a stepchild or a family member, or if you adopt privately. Next slide, please. Next leave we're looking at is statutory paternity leave and the pay that goes along with that. So statutory paternity pay is paid for up to 2 weeks of paternity leave. Your employer can give you longer amount of leave than 2 weeks, and your employer could pay you for more than 2 weeks, but that would be contractual. It's not statutory. You only have the statutory right for 2 weeks of paternity pay. It's the same amount again, £184 and 3 pence per week, or 90% of your average weekly earnings per week, whichever is lower. And just worth noting that that figure of £184 and 3 pence changes quite often. Governments review the rates of benefits and quite often increase them. It has been recently on an annual basis. They don't have to, but it is regularly reviewed, and it's usually around April when the new statutory pay rates are published by the government. So while I'm giving you the figure of £184 and 3 pence now, you need to keep a check, because that will change at some point next year. It is likely to change around April time. So that applies for all statutory pay. So keep an eye. The best place to find out is .gov.uk. That's the most reliable source of rates of pay. Again, an exclusion in that you would not receive statutory paternity pay if you have already received statutory adoption pay for the same child. Next slide, please, Rob. To qualify for statutory paternity pay, there are 2 different criteria for qualifying. One would be following the birth of a child. The second lot of criteria is following adoption. So if we look at the birth of a child first, again, you have to have been employed by your employer for at least 26 weeks by the last day of the 15th week before the expected week of childbirth. You need to give your employer 28 days notice of when you want the statutory pay to start. And again, there is the minimum average weekly earning of £123. And like maternity pay, where you're claiming statutory paternity pay, so SPP, you'll still qualify for SPP if the baby is stillborn or if the baby dies after birth. Next slide, please. Criteria here to qualify for SPP following an adoption. Again, you have to be employed by your employer for at least 26 weeks. This is by the last day of the week in which the adopter is matched with a child. Excuse me, if you remember, just a couple of minutes ago, I said you can't get statutory paternity pay if you've also had statutory adoption pay. So the statutory paternity pay is paid to the partner who is not receiving adoption pay. So the criteria following an adoption would be the 26 weeks at the last day of the week in which the adopter is matched with a child, or the date in which the child arrives in the UK. You would then also need to confirm to your employer that your partner is receiving statutory adoption pay. Your employer may want proof for that if your partner doesn't work for the same employer, and you would need to provide proof that your partner is receiving statutory adoption pay. You need to give 28 days notice of when you want your statutory paternity pay to start. And again, there is the minimum average weekly earnings of £123 to qualify for statutory paternity pay. Next slide, Rob. Statutory shared parental pay. If you were at the webinar last week, you will recall that statutory shared parental leave is when both parents or a parent and their partner, whether that's birth or adoption, split their leave between each other. The same thing can be done with pay. So you can split maternity pay between two parties. Likewise, you can split adoption pay between two parties. And statutory shared parental pay is going to be paid for up to a maximum of 39 weeks, in the same way that statutory maternity pay is paid for a maximum of 39 weeks and statutory adoption pay is paid for 39 weeks. However, the difference for the statutory shared parental pay is that the time that you would qualify for the pay is minus any weeks for which a mother has taken statutory maternity pay or an adopter has taken statutory adoption pay. So if we look at the case of a birth and think back to statutory maternity leave, there is a requirement that you must take at least 2 weeks leave after a birth. So the birth parent will then receive 2 weeks worth of statutory maternity pay when they take their statutory maternity leave for those 2 weeks. That would mean there would only be 37 weeks of statutory maternity pay to share between the birth parent and their partner, because the birth parent has already taken 2 weeks worth of pay. So it's 39 weeks minus whatever the birth parent or the adopter parent has already taken. And it's the same rate again, it's £184.03 or 90% of average weekly earnings, whichever is the lower. Next slide, please, Rob. So to qualify for shared parental pay, you've got to either qualify for maternity pay or statutory adoption pay, or you qualify for statutory paternity pay and your partner qualifies for statutory paternity pay or maternity allowance or statutory adoption pay. That's where the mixture comes in between maternity and adoption and the shared parental leave and pay. And because it's shared, you can't receive shared parental pay if your partner is receiving maternity pay or the adoption pay or paternity, not parental, but paternity pay. Because, as I said just before, the period for which you get the pay or the amount of pay you get is less what's already been taken by the birth parent or the adopter parent. And you must give your employer 8 weeks notice of wanting to take and to receive shared parental pay. Next slide, please. Statutory parental bereavement pay is paid to parents on the death of a child. It can be paid for 1 or 2 weeks of leave, and it's the same rate, £184.03, or 90% of average earnings, whichever is lower. Next slide, please. So to qualify for the bereavement pay, again, you've got to have been employed by your employer for at least 26 weeks. and that would be up to the end of the week immediately before the week of the death, or if it's stillbirth, the week of the stillbirth. Again, you've got to earn at least an average of £123 per week. And 28 days before you want to start taking the bereavement pay, you've got to let your employer know that you qualify for it. You've got to let your employer know when you want to take the pay, because the pay is related to 1 or 2 weeks leave. You can take that leave, you can take separate weeks, or you can take 2 weeks together. So you need to tell your employer when you want to be paid for those 2 weeks. And you've got to give your employer the date of the child's death or the stillbirth if it's part of pregnancy. Thanks, Rob. Next slide. Holiday pay. Statutory holiday pay is paid for 5.6 weeks of statutory annual leave. Now, employers can give more than 5.6 weeks of leave, in which case you would receive more than 5.6 weeks of pay, but that would be contractual leave and pay. Your statutory entitlement is set out under the working time regulations, 5.6 weeks of leave, so you're entitled to 5.6 weeks of pay. The 5.6 weeks is prorated to the number of days that you work. So if you work 5 days per week, then you're looking at 28 days. If you work 4 days a week, then it's 4 times 5.6. If you work 3 days a week, then it's 3 times 5.6. And the pay is the same accordingly. It relates to the amount of leave that you would take. Now, there is a difference between the statutory leave in relation to what pay you are entitled to. The first 4 weeks of statutory holiday are paid at your normal rate of pay. And when I say normal, that's what you would have been paid if you had been at work. And I'll come on to that in a moment. The additional 1.6 weeks are paid at your basic rate of pay. So your basic rate of pay will be that which is set out in your employment contract. It should be indicated on your pay slips. If you're not sure, again, take advice, because there are 2 different rates of pay for your statutory leave. Next slide, please, Rob. So, a normal week's pay. It is quite complicated, the way that you have to calculate a normal week's pay for annual leave purposes. It includes your basic pay, as I said, that rate of pay which is set out in your contract of employment or on your pay slip, however many pounds it is per year, whether it's 20,000, 30,000 per year, whether it's expressed per week or per month, your basic pay. But it also includes any payments or allowances that are linked to your job. So things like shift allowances, unsocial hour payments. It can also include productivity bonuses and commission payments. And it can also include overtime. Now, there are 3 types of overtime that can be included in the calculation of a normal week's pay. The first is contractual overtime. And contractual overtime is overtime which you are obliged to work because it's set out as a term of your contract of employment. So your employer must offer you the overtime and you must work that. For example, your contract may say that your normal hours of work are Monday to Friday, 9 till 5. But then there might be a clause in your contract which says, in addition to your normal hours of work, you must also work 8 till 12 every other Saturday. So that every other Saturday, 8 till 12, is in addition to your normal hours of work, Monday to Friday, 9 to 5. You must work every other Saturday because it's part of your contract. So that would be contractual overtime. The second type of overtime is non-guaranteed compulsory overtime. So it's not contractual as the first type I've just mentioned, but you are obliged to work that overtime if your employer offers it. So your normal work hours, Monday to Friday, 9 to 5, but your line manager says to you, oh, by the way, I need you to work next Sunday from 9 till 3, and you are obliged to work next Sunday from 9 till 3 because your employer has asked you, then that would be non-guaranteed compulsory overtime. Excuse me. The third type of overtime is voluntary overtime. So that's overtime which your employer offers you, and you can then choose to work whether you want to work that overtime. Now, for voluntary overtime to be included in your holiday pay, you have to work that overtime on a regular basis. This stems from a Court of Appeal decision in 2019 called the Flowers case. And what the Court of Appeal said was basically, as I've just explained, that you're entitled to have voluntary overtime included in the calculation of holiday pay if that voluntary overtime is worked regularly. Unfortunately, the Court of Appeal did not define what regular means. And we don't have any appeal court cases defining what regular means. So it's up to negotiation with your employers what you mean by regular. As an example, the Cambridge Dictionary defines regular as something which happens often. The Collins Dictionary describes overtime as an event that happens, defines regular as an event that happens often. And dictionary.com defines regular as normal or customary, or something which happens evenly or uniformly. Well, really, none of those definitions are particularly helpful if you are arguing with your employer that you have worked overtime regularly and it should be included in your holiday pay calculation. Within the NHS, as an example, regularly worked overtime is considered to be overtime which is worked in 6 months out of a 12-month period. Because to be regular, it really has to happen more often than not. So the agreement within the NHS across most of the NHS employers is that if somebody works overtime in 6 months out of 12, then that overtime has to be included in the calculation of their holiday pay. That said, there is no obligation on any employer to follow what another employer does. It has to be regular. If in doubt, we need to try and negotiate regular. Ultimately, if there is an argument that can't be resolved between an employer and an employee, then ultimately the employment tribunal would need to resolve that. And that's where you need to take advice from the RCN if you are in dispute with your employer over what would amount to regularly worked voluntary overtime. Do not try and argue that on your own if your employer is not being particularly cooperative. Get advice, get support. Next slide, please, Rob. So, how do you calculate a week's pay for the purposes of your 4 weeks statutory leave, which is paid at a normal week's pay? At the point at which you would start your annual leave, then you calculate backwards for a period of 52 weeks. And that 52 weeks is called the reference period. You take an average amount of pay over that 52-week period. So you would look at everything that you've been paid during that 52-week period, and you would average it out in line with the amount of leave that you were taking. So for example, if you were taking a week's leave, then you would look at what an average week's pay was. If you were taking 1 day or 2 days or 3 days leave, then you would work out what an average day's pay is. If you've been employed with your employer for less than 52 weeks, then that reference period is simply the number of weeks you've been employed. If in that reference period you have not worked, so you may have been off sick, or you may have had another period of annual leave, then you don't count that week in the reference period, and you would go back further to include a week that you were at work. So if you're due to take annual leave tomorrow, and you would calculate 52 weeks back from tomorrow, if you'd had 4 weeks leave in that 52-week period, then you would go back 56 weeks, because you would find the most recent 4 weeks to make up for the 4 weeks leave that you've had in which you didn't work. It is not weeks in which you were not paid, it is weeks in which you did not work. So you would substitute a non-working week with a working week. You cannot go back indefinitely for calculating the reference period. You can only go back a maximum of 104 weeks. So you can't go beyond 104 weeks when you're looking to try and work out an average 52 weeks. And as I said before, the voluntary overtime must be regularly worked. But as I said, we don't have a statutory definition of regularly worked. Next slide, please, Rob. Last type of pay we're going to look at is statutory sick pay. At the moment, statutory sick pay is paid from the 4th calendar day of absence due to ill health, and it's paid for up to a maximum of 28 weeks for each period of absence. I say at the moment because this is one of the criteria that we know is going to change. This government has indicated as part of its consultation regarding the Employment Rights Bill that it's going to be changing various employment-related rights, and this is one of the rights that they are proposing to change. And at some point in 2025 or possibly 2026, statutory sick pay will become a day one right. So at the moment, you only get paid from the 4th day of absence. So if you're only off sick for 1, 2, or 3 days at the moment, you don't get any statutory sick pay. But in the future, you will get statutory sick pay from day one. So watch out for announcements, watch out for any info that you receive from the RCN, watch out in the news, because we don't know when this is going to change, but we know it is going to change sometime from next year. Again, the rate of statutory sick pay is set by the government at £116.75 per week. And again, that can change. So watch out for any changes. Again, as I said earlier about other types of statutory pay, it's usually around April when the rates are reviewed and changed. Now, even though the statutory sick pay is expressed as £116.75 per week, it can be paid at a daily rate if you're not off sick for a full week. So you could be off sick for 5 days. You would then qualify for 2 days statutory sick pay. It's less than a week, so you'd have to calculate what the daily rate was. And what I've got on that slide, it shows you how to calculate the daily rate. Again, these calculations for statutory pay are not easy. So again, if you're in doubt, contact RCN Direct, get advice from the RCN about how to calculate any sick pay if you are questioning what your employer tells you about how much you would be entitled to. Final point just to make about statutory sick pay. We said it was available up to a maximum of 28 weeks for each period of absence. However, if there are 56 days or less between 2 periods of sickness absence, then those 2 periods count as one for the purposes of statutory sick pay. To get a second 28-week period of statutory sick pay, there has to be at least 56 days where you have been at work since the last period of statutory sick pay. Next slide, Rob. So to qualify for statutory sick pay, you have to earn at least an average of £123 per week. As I say, you've got to have been absent from work due to ill health for more than 3 days. Those 3 days also include any roster days off. So if you're working a shift rota and your shift pattern is work Monday, Tuesday, off Wednesday, Thursday, Friday, back at work, off Saturday and Sunday, if you phone in sick on Monday and you remain sick Monday, Tuesday, Wednesday, Thursday, even though Wednesday is a day off, it still counts as part of your sick day, and it still counts as part of the 3 qualifying days. So in that scenario, you would have been at work Monday, Tuesday, off Wednesday, back at work Thursday, you're off sick. So your first 3 days would be Monday, Tuesday, Wednesday. You would then start receiving statutory sick pay from the Thursday, which is day 4 of your sickness, not day 4 at work. It's day 4 of the sickness. And also you need to provide your employer with proof that you're ill. So during the first 7 days of any sickness absence, you can self-certify that you're too ill to work, and your employer has to accept your self-certification. If your employer insists that they want a doctor's fit note during those first 7 days, GPs can provide a fit note, but a lot of them will charge you for that fit note because you have the right to self-certify. So if your employer insists that they want a fit note before they will give you your statutory sick pay, then your employer should be paying for that fit note. If you are ill for more than 7 days, then GPs will provide you with a fit note without any charge to certify that you're not fit for work, because the law says you can only self-certify for the first 7 days. Next slide, please, Rob. Just here, reference periods I touched on earlier on. If you are in doubt, if you want to check your entitlement, then the best place to go is gov.uk. Simply Google gov.uk, and then when you get to the first page, put in holidays or time off or sick leave or statutory pay, and it will take you to the relevant sections, and it will set out your entitlement, the qualifying criteria, and the amounts, if you've got any doubt. Alternatively, as I say, you can ring RCN Direct and they can provide advice for you. In addition to RCN Direct, you can also contact ACAS, telephone numbers there and the website for advice, or you can contact Citizens Advice Bureau. They will be able to help you as well. That's the end of my presentation. Thanks for listening. Hand back over to my colleague, Steve, who will talk about the RCN and benefits of membership. Thanks.
Thanks, Barry. Just before I go into the content of the next slide, can I just highlight a couple of things that are in the chat? The first is how to contact RCN Direct for help, advice, and support. So within there, you've got the opening times, the phone number, and also the link to the web page that includes the Get Help link, so you can talk via web chat or be signposted to our advice guides. And secondly, just a reminder that we have got the Q&A tab open. So if anyone has any questions for Barry that arising from anything that Barry said within the presentation, please do drop them into the Q&A section, and we can pick those up at the end. So just in terms of what's on the slide there, why should we join, or why should you join the Royal College of Nursing? I'm conscious going to be talking to a group of people, some of whom are going to be members and some are not RCN members, and that's absolutely fine, because I think some of this information is as relevant to members or is as useful to members as non-members. because frankly, a lot of members do not know the full range of support and advice and services that they can access as part of their membership. So in terms of what's on the slide, professional development, first of all, we support lifelong development, access to our learning library. That'll include our resources, Europe's largest nursing library, forums and networks. A specific plug for the library service. Many members don't access that and could you really usefully access the library service for support, either during training and learning that they're undertaking outside of work, or just generally our library staff are on hand and are very, very helpful and supportive for signposting you in the right direction. And you can access it part of your membership from wherever you are. Workplace support. So this would fall to regional staff. So my team. So if you have any issue and you need support and guidance within your workplace, then of course RCN Direct is your first port of call for any advice in the first instance. But it may be that you're put through to one of our team, one of our officers or senior officers, or one of our workplace reps who would come and support and advise you in the workplace. Legal advice. This is a sort of self-explanatory really, but the largest in-house legal team of any UK trade union. Two sides to this predominantly. First is the employment law advice that you'd receive via our regional staff in our offices, access to our employment legal team. But secondly, our regulatory team. So those issues that come up for registrant members, nurses, with the NMC, with the Nursing Midwifery Council. So if you are in the unfortunate position that you're referred to the Nursing Midwifery Council because your employer or whomever think that your fitness to practice may be impaired, then and there's some professional conduct issue, then our legal team will provide you advice, support and guidance and represent you throughout that process. Member support as well. This is a whole range of other services, many of which are not known to lots of our existing members. These across the whole piece: immigration advice, welfare guidance to support you financial well-being if you're dealing with the drop of income or what sorts of state benefits that you might be entitled to or other financial support. Career coaching, so that might include CV writing, preparing for interviews or career planning. I've spoken to some people personally within within our region who have accessed this, didn't know they could, about 40 years of membership in total, didn't know they could access it, and recently found it really helpful to look for the next step within their career and find out what they want to do. Counselling, it's completely outside of any representation thing. It's something that you're entitled to receive as part of your membership. So if you're going through a tough time and you need some help and support in that side of things, you can be referred to counsellors. Peer support for members with disabilities, and a handy guide to common English expressions, which you've got the link there on the slides. Careers advice as well. I touched on career coaching, which is one of our services within our member support services, but also just generally there's a lot of information accessible via our website in the first instance about careers advice and how the organisation, how the RCN can support members with the next step in their career and what to do. There's a QR code at the foot of that slide that you can access more information, and please do so. Want to make sure that if you're not a member, you realise that you're informed as to what you can access as part of your membership should you join, but also, as I mentioned before, if you're already a member, then this is all that's available to you and you've already paid for it as part of your membership. So please do access it because we want to make sure that as many members do as possible. I'm going to turn to the Q&A now just to see whether we've got any questions that I can pass to Barry. Doesn't seem that we have any just yet, but I can see a few comments in the chat. Okay, I'll give just a minute or so more to see if anyone's got any questions. Just while I wait for that, I just want to take a moment to thank those who are working behind the scenes to put on the event today. So our audiovisual team in the form of Rob, Gary and Will, a marketing team, Rihanna, Ollie and Jitten, and of course Barry, who's delivered the presentation today. Really much appreciated. And I can see a question in the chat, Barry, from Alani K. I'm just going to read that to you. Thanks for the information. I'm just wondering if an employer have the right to switch fit note from you, maybe fit for work with amended duties to full not fit for work.
If I've understood the question right, Steve, Absolutely not. Your GP or a nurse practitioner or a midwife, there are a list of authorized professions which can issue a fit note. They issue the fit note, they decide what goes in the fit note, and that's what issued to the employer. The employer cannot change what's on a fit note and certainly cannot require you to change what's in a fit note. So usually it comes from a GP, and the GP may indicate on the fit note that you would be fit to return to work with amended duties. They may also give examples of what those amended duties might be on the fit note. Your employer can't change that. If your employer refuses to allow you to return to work on amended duties, then your employer is going to have to do what's called medically suspend you, because they are not allowing you to back to work when you are fit to return with amended duties. So the employer can't say, we're not having you back to work on amended duties, therefore we're going to say you're not fit for work, full stop, because it's not for the employer to decide, it is for the person issuing the fit note, as I say, usually the GP. If that kind of situation arises, if your employer is trying to put you under pressure to return to full duties when your GP is saying to you amended duties or on a phased return, then you need to contact RCND for advice if you're a member of the RCN. If you're not a member of the RCN, then you need to join to get that protection and get that advice. But no, the employer cannot change the fit note. Absolutely not.
Thanks, Barry. Got another conversation which I've picked up in the chat. Barry, if I can just read that one to you. It says, if you bring in a sick note, can your manager leave out 2 days before the ended date and then decide not to pay you for the 2 days that she's left out, please? I think it touches your previous answer as well.
If you bring in a sick note, can your manager leave out 2 days before? I'm not quite sure what the question's trying to ask. If you are off sick for, let me just try. If you're say you're off for sick for 14 days, are you asking if your employer then only has to pay you for 12 days and forget about 2 days? No, they can't. What you would do is you would not get paid for the first 3 days because that's the qualifying 3 days, but then you must be paid from day 4 to day 14. They can't just suddenly decide not to pay you for 2 of those days on which you're entitled to statutory sick pay. Absolutely not. That would be an unlawful deduction from wages. Again, you would need to take advice on that.
Thanks, Barry. There's also reference in the chat to ask, can this information be sent to a particular employer and workplace? We're not going to be sending this out to everyone's employers en masse, of course, but what I would say is if you have any particular concern with the employer that to which you're referring in the chat, if it's an issue that's affecting you or RCN members there, then please do yourself or encourage RCN members to contact RCN Direct, because we'll be able to give you individual advice and support on an individual issue that way. Just going to turn back to the chat there. I can see no more questions that have come in. I'm just going to pause for a few seconds to see if anyone, one last opportunity really, to see if anyone does have anything else that they'd like to ask Barry. Okay, there's a number of comments, Barry, in the chat, just saying thank you, very informative. So I wanted to share those and pass them on. Just generally before we close, I hope that you have all found this this session to be useful, to be informative. We're going to put a link in the chat, if we haven't already done so, to an evaluation form for this session. And could I ask that as many of you that as possible, please complete the forms. It's really helpful to us to learn from the feedback. And just to continue to ensure that what we do and what we deliver and what we share is worthwhile and useful to you. So be grateful if as many of you can complete that as possible. We'd really find it useful. Barry, I don't believe there's any more questions in the chat or in the Q&A, so I think that may be it for this afternoon.
Thanks very much, Steve.
This evening, I should say.
Thank you for your comments in the chat. I'm glad you found it useful. Thank you.
Okay, so we're going to bring the event to a close now. Thanks everyone for your time attending today. As I do look at the chat for the links that we've referred to, please do complete the evaluation form. Thanks to everyone for joining, and wish you all a Merry Christmas when it comes.